Good morning, my lords. I have two more short points of principle before turning to the application of the facts to those principles. So, my fifth of 6 points is that the provisions of Section 11 and Section 12 should not be interpreted and applied in a manner which would give rise to outcomes which are absurd or unworkable. That's not just a general observation that can be applied to any statute. It's particularly valuable here because Parliament has sought to ensure that end by requiring a value judgment to be made by the judge as to the appropriateness of applying a law other than that provided under the general rule. And appropriateness for these purposes must include, we would submit, avoiding an outcome which is illogical, impractical, or absurd. And the need to avoid construing and applying Section 12 in a way that would result in an absurd or unworkable outcome underpins the purpose of conflict of laws, rules. As Lord Justice Mance, as he then was, said in Rifesson, which we set out the relevant passage at paragraph 37 of our printed case at page 91.
Sorry, in which case?
It's the Rifesson case. It's not in the bundles, my lord, but we cite it. We cite the relevant passage at paragraph 37 of our printed case at page 91.
Sorry, so why is it not in the bundles if you've cited it?
I'm so sorry, my lord. That's an oversight. I'm sorry for that. His Lordship said the conflict of laws does not depend, like a game or even an election, upon the application of a rigid set of rules, but on a search for appropriate principles to meet particular circumstances. And indeed, in the joint consultation paper, the Law Commission explains, and we quote this at paragraph 47 of our printed case, page 93, that the choice of law should be, and seem to be, reasonably appropriate in the circumstances. It's necessary that our choice of law rules should not be capricious in their operation. My lord, the final and sixth point concerns the threshold for successfully displacing the general rule. The Act, as it applies in Part 3 to torts and delicts, seeks to balance the benefits of certainty and predictability with an acknowledged need for flexibility. It achieves certainty by the provision of the general rule in 11(2)(a) and in the threshold required to displace it, and sufficient flexibility and thus fairness in a given case through the exception provided in 12(1). Now, the justification for why the threshold to invoke the rule of displacement is high is obvious. It's to ensure that the general rule is not emasculated. But it would be equally wrong in our submission to gloss the plain words of Section 12 and calibrate the threshold at a level at which the exception itself is emasculated or becomes illusory. That's a point stressed by Dicey in a passage quoted at paragraph 49 of our written case, page 94. The exacting threshold is not so high as to render the displacement of the general rule illusory. It's not, for example, necessary to show that the connection to the country who law applies under Section 11 is insignificant. To the same effect...
So which paragraph number is this, sorry?
I'm so sorry, but that is paragraph 49 of our printed case at page 94. To the same effect, we'd submit, whilst it is right that it is relatively unusual for Section 12 to be successfully invoked and the general rule displaced, that should not in any sense be a proxy for the application of the plain words of the exception itself. There is not some separate or additional test of exceptionality or rarity in addition to the requirements of the plain words of Section 12.
So you don't accept that Lord Wilberforce's comment about being very rare cases where there would be displacement.
Well, my Lord, I think I'd put it the other way around, if I may, which is that that shouldn't be a guiding principle that shouldn't become a guiding principle for the applications of the plain words of the statute. They say, is it substantially more appropriate? You shouldn't reach that answer by reference to the comments of Lord Wilberforce, that it will only be in a rare case.
Oh, so James Eady has accepted this case is rare, but has also said it's not determinative. Just because it's rare is not determinative. And I think you agree with both of those propositions.
Simply, absolutely. Each case has to be examined on its facts through the prism of the actual statutory test. I think we're all agreed about that.
And just while we're on the threshold, is it agreed that we're talking about 11.2a and not 11.2c?
Yes, my Lord.
Right, even in respect of the claim for false imprisonment?
Yes, my Lord.
I think you might have told us that yesterday, but I just wanted...
Yes, my Lord, if this were a claim just for false imprisonment,
Yeah.
and what the remedy sought was purely for loss of liberty, then it may well be that the appropriate way through would be 11.2c, not 11.2a. But in this case, having regard to the way that it is put, I don't think there's any issue between the parties that the gateway is 11.2a.
Thank you.
And of course, as my Lord would have seen, as the Court of Appeal in this case identify, it's harder to displace the general rule when you've gone through the gateway of 11.2c, because you've already decided, by the time you come to displacement under Section 12, where the most significant elements of the tort relate to the country to which the general rule applies.
That was a point made by Lord Clark in the...
Precisely, my Lord, yes, precisely. Yes. My Lords, that's all I wish to say about the principles. Could I turn to part 2 of my submissions and address the application of those principles to this particular case? And can I start by first taking you to the pleadings and just to outline the nature of the case as pleaded, which is obviously an essential starting point and perhaps end point when one looks at the statutory test, what it is that one has to have regard to. And my Lords will find the latest iteration of the particulars of the claim at page 254. Can I just start briefly with the caveat? I'm so sorry.
Amended particulars of claim.
Yes, thank you, my Lord. At page 254, I can take you in a moment to what we say are the most important elements of the tort, the knowledge of the defendants, the intent of the defendants, the acts and omissions of the defendant, their relationship with the damage that was incurred. But before I do so, could I just flag up for you an important caveat at paragraph 2 of the pleadings, which is that the knowledge of the claimant and the claimant's legal advisors as to many of the key facts upon which this claim is based are, by force of circumstance, limited. And that gives rise to one particular feature pertaining to the law that applies, because although the case proceeds on the basis of the pleaded facts assumed to be correct, there are some facts that are simply unknown. In particular, what is unknown in this case are where the claimant was at the date at which the questions were sent by the defendant, and perhaps more pertinently, because it might be a different answer, where the claimant was at the times at which answers were sought to be extracted from him, when the injury was sustained. We don't know.
What I have in mind here when I asked a question of Sir James, I think, was the footnote 2, under the section in your case, which is headed relevant factual background. And there's a reference there to the June 2018 report. And halfway down that footnote, it is said that the existence of the facilities has never, at the time, ever since admitting the Black Sites programme in 2006, there has never been confirmation of the location of the sites. And is that still the position?
Certainly from the CIA, the Intelligence Committee itself, which is of course an arm of the United States government, has made the findings that it has, albeit all we have is a summary, highly redacted summary, executive summary of their report. The main report has never been released into public. But yes, as we understand it, that remains the position, and that would be consistent with a neither confirm nor deny defence that's been entered by the defendants here. And so this case has been effectively put together by using the limited sources that are available in the public domain. But the key element, or a key element of the tort here, or certainly the element that would give rise to the application of the general rule, the identity of the country or countries in which the general rule might spring from is unknown. We simply don't know in which countries the questions posed by the defendant were put to the claimant and the relevant injuries sustained. And that has some practical consequences, which may not, I accept, bear directly upon the interpretation of the Act, but it's worth just setting out what they are. It may be that the identity of those countries at which the injury was sustained will remain enclosed. Maybe the claimant will never know. And we will proceed to trial on the assumption that it could be all of the six or one of the six. Expert evidence will have to be obtained in respect to the legal systems of all those countries, experts perhaps called. But it might be 1, 2, 3, 4 of those countries is in fact irrelevant. The legal system is irrelevant because the relevant injuries were not sustained in that country. Now, we may never know that. Equally, it may emerge, and it is absolutely not fanciful on the facts of this case to suggest it may emerge that there are other countries in which Mr. Zubaydah was held and in which questions from the defendant were put to him under torture. Now, if that matter remains enclosed, we'll never know that. We'll never be able to identify and address the legal system. Now, of course, if the appellant is correct about what they contend is the paramount and determinative significance of the location at which the injury was sustained, and that's just an unfortunate consequence of the statutory scheme. But it is worth bearing in mind, we say, as to where this takes us, in a framework that is designed to allow parties to litigate cases fairly and sensibly before the court. Could I then, if I may, turn to the pleadings in a little more detail? Between paragraphs 3 and 25, we set out the factual basis upon which the claimant... between 3 and 25, we set out the core basic facts of, so far as are known to the claimant, about where he was detained and the treatment that he received. We then, at paragraph 26, effectively summarise the basis on which we say the the basis of the defendant's engagement. We frame that as complicity. That's not put as obviously as a term of legal art. You've seen paragraph 26 about the date of knowledge, but it's also worth then going on to 27 and 28. So 27 is notwithstanding their knowledge that the claimant was being detained and tortured. From May 2002, for a number of years thereafter, they sent numerous questions to be used for the purposes of attempting to elicit information of interest to the defendants. And they did not seek any insurance, nor take any steps to discourage or prevent.
That's paragraph.
That's paragraph 27, my lord, at page 266.
Got it. Thanks.
And then at 28, we go on to draw some inferences from that. Firstly, under A, that they sent those questions in the knowledge and with the expectation and or intention that the CIA would subject the claimant to torture and extreme mistreatment at interrogation sessions conducted for the specific purpose of attempting to extract information in response to those questions. And then B, the defendant sent those questions in the knowledge and with the expectation or intention that the torture and extreme treatment would be inflicted on the claimant at the black sites where he was being held without any access to representation, without the ability to vindicate his rights, not to be subjected to torture. C is the knowledge of how wrong that was. And then D, which is relevant not least to our case on causation and the link between the tort and the constituent element of damage. As a direct result of receiving those questions, the CIA conducted interrogation sessions at the black facilities during which the claimant was subjected to a range of brutal interrogation techniques which constituted torture, cruel, inhuman, degrading treatment, and which were intended to compel the claimant to provide information in response to the questions from the defendants. And this is the central underpinning that is common to all the English and Welsh law torts that we plead in the particulars of claim. The constituent elements of those, the core components of it, remain constant from tort to tort. They are the knowledge and intention, the acts and omissions, and the damage that was caused as a direct result of those acts and omissions. Could I just show my lords how those are pleaded? And if we could turn, please, to misfeasance in public office, which is at page 291. And paragraph 46, in particular, can I just take you to paragraph 46, little c. The acts and omissions were specifically intended to injure the claimant, whom the public officers knew and intended would be subjected to torture and severe mistreatment by the CIA as a direct result of those acts and omissions. And D, alternatively, they committed those acts and omissions in the knowledge or with reckless indifference to the illegality and to the consequences. 47A, which is an averment in support of that allegation, is from at least May 2002. They were expressly aware was being subjected to treatment at CIA-operated detention facilities, and so the requisite knowledge is inferred. And then...
Which paragraph?
I'm sorry, my lord, that's 47 little a, page 292. And then if you'd be so kind as to go down to little c on the same page, The public officers must also have known that providing questions to the CIA for use in interrogations of the claimant without seeking assurance he wouldn't be tortured, they would subject him to torture and mistreatment during those interrogations at the black site facilities. Again, this conducted for the specific purpose of eliciting information from the claimant in response to those questions. And the CI would take and derive encouragement to commit some acts from receipt of those questions. In support of the averment of reckless indifference, paragraph 48b, the next page, 293, the following is pleaded. The security service was expressly informed on at least 2 separate occasions in May 2002.
Sorry, which paragraph again?
I'm saying, my Lord, it's paragraph 48b,
Yes, thank
which
you.
my Lord will find 293. The SAS was expressly informed on at least 2 separate occasions in May 2002 that the claimant was being subjected to harsh interrogation techniques, including sleep deprivation, which 98% of the US Special Forces would have been unable to withstand. And it's therefore pleaded meant that they had direct awareness of the extreme mistreatment and probable torture. Well, we pleaded that with somewhat degree of an understatement. One reflects that US Special Forces would be trained, the most elite units would be trained, expressly trained, to withstand interrogation under torture. One can get a sense of the power of that assessment and the knowledge and the level of knowledge that it gave to these defendants. And that's why we plead it would have been obvious to them that any questions provided to the CIA for use in interrogations would directly result in the claimant being subjected to interrogation techniques which constituted extreme mistreatment and torture. And my lords, it's the same essence, the same core ingredients of knowledge and intent that are also pleaded in respect of conspiracy. I say, and causation of damage. The direct relationship in respect of conspiracy. So one will see at the top of page 294, which is paragraph 49A, that there was a conspiracy in which the defendant's part was to put questions to the claimant during unlawful interrogation techniques to obtain the answers, and that those answers would be supplied to the defendants. The knowledge is set out in paragraph 49B. He was being held by the Americans in a secret detention centre. He was being tortured there, that the provision of questions would likely be elicited under torture. And that's why we say that the requisite intent is effectively the same in conspiracy, the same basis as it is in misfeasance. Trespass to person is pleaded at paragraph 51, page 295. And again it is put primarily on the basis of what the defendants here did, which is providing the questions and the knowledge that they would be put under torture to elicit the answers. It's the same background facts in 51A and B, and liability is pleaded under C as arising because of what these defendants did. To similar effect, my lords, negligence is pleaded at paragraph 53 and 54. At 54, we aver that the duty of care that we say was on the defendants arose because of what they knew. So precisely the same knowledge from which we take intent from the intentional torts serves as the basis for at least the foreseeability element and proximity element under negligence. And it's also C under 54C for what they did, which is again precisely the same basis as the other torts that I've shown you. And again, at paragraph 55, my Lords will find at 297, duty is breached because of what the defendants did or did not do, which is again, in essence, the same as the intentional torts. It's the sending of multiple questions to the CIA, as we set out in A and B, in circumstances in which they knew or ought reasonably to have known that they were going to be extracted under torture.
It's right in saying, though, just going back to paragraph 51C,
Yes.
on page 295, that in relation to trespass to the person, including false imprisonment, the allegation is in relation to joint liability, whereas I think in relation to the other torts, it's actually what one might call primary or sole liability.
Yes.
Right.
My Lord, that is right. I mean, liability for trespass could certainly be found here on a more narrow basis of joint liability than common design. So it could be their liability is simply to take a Petrie and Lamont classic type of case, simply because they procured. So mere procuring of a trespass could give rise without having to invoke more complicated notions of common design. But my Lord is right to identify that there's a slightly broader pleading in respect to trespass than the other torts.
Isn't that because, with regard to, at least with regard to trespass, although you've recently, you stressed, I think, earlier on, that damage was caused as a direct result of what the defendants have done, if you were just faced with this example of trespass to the person, you would normally, I think, well, for trespass to the person, you need direct conduct by the defendant directly to the claimant. You know, that's a feature of trespass to the person. And one would imagine that is not going to be easy to satisfy here, which is presumably why you've gone for joint liability. That aspect of directness would have seemed somewhat problematic.
Well, my Lord, I'd say with respect that might not be correct. If I intend to assault Mr. Jaffe, but rather than use my own fist, I direct Mr. Craven to do it, I would say I have procured a tort. It's irrespective whether or not Mr. Craven has acted tortiously. I am liable for trespass because my intent was that Mr. Jaffe be injured.
Right.
Now, it's pleaded more broadly, I accept, in respect of trespass. But and trespass is the only aspect of the pleading in which it could be arguably said that the defendants are liable for more than the direct and immediate result of their acts and omissions. So under the other pleaded torts, it's tight. The damage that's recovered isn't all the damage sustained whilst being detained by the CIA. The damage is the pain and suffering endured when the answers to those particular questions were sought to be extracted. Now, there is room within the scope of the tort of trespass here to say, well, the nature of the common design is, from at least the point at which you joined it, your role was same material, you're liable for all of it. But it's equally open for a court, when they actually look at the facts and are able to see it, to say, no, you're liable in trespass, but you're not liable in trespass for the whole thing. You're liable in trespass for the assaults and batteries that were occasioned as a direct result of your tortious act.
And that's your case, is it?
Yes, my Lord.
Not for the whole thing.
No, for all the other torts.
But for the assaults occasioned. How did you put it?
Yes, my Lord, for all the other torts.
How did you put it, the form of words you used? Not liable for the whole thing.
No, but
occasioned by
the when the answers to the questions put by the defendants were extracted.
Thank you.
And that's important, we say, because it shows a direct link between the damage complained of and these defendants. We're not saying they're liable for everything that the CIA did in those secret prisons.
And is the conspiracy claim limited in the same way?
It is, my lord, yes. And misfeasance and negligence.
Yeah, I mean, they're all subject to that same restriction, are they not?
They're all about the direct damage caused by the acts and omissions of these parties, these defendant parties, to this claim. My lord, could I turn to the assumed facts and the actual statutory test?
Can I just ask you about your pleading of the case under foreign law?
Yes.
And how you put the case on misfeasance in public office?
Well, we don't.
Doesn't appear to be there.
No, because, my lord, in our trail of equivalent foreign laws that would cover the acts and omissions of these defendants, we were unable to identify an analogue in those foreign laws to our long and important and constitutionally established tort of misfeasance in public office.
Is that a point that you're making? That makes an important point?
Well, my lord, it is certainly a point that goes into the factors that point to the significance of the connection between the torts and this country. And I'll develop that, if I may, when I come to that limb of Section 12. I'm so sorry, my lord.
When you come to deal with it, you might want to consider whether it's appropriate for that issue to be addressed in the context of Section 11 and Section 12. Sir James was making the point yesterday that, of course, the choice of a system of law as having the closest connection will result in pros and cons to the different sides. That may just be a disadvantage of the choice of one legal system, but it's not a reason for not choosing it.
Well, that may, as a matter of principle, be right. But we would say on the facts of this particular case, looking at the parties and the connections with the country, the fact not least that there is an absolute analogue, that if these facts are proven, there would be misconduct, the criminal offence of misconduct in public office would be committed, is a feature that ties these torts to this country.
Why do you say it ties these torts? Why doesn't it just tie that tort?
Well, I suppose what it also does is it illuminates why, when one's asking is it going to be substantially more appropriate to apply the law of this country, it's a reflection as to why the answer to that must be yes, and why it would be a illogical result if the answer were no.
And it's being assumed, I think, that we're in an all or nothing position here, are we? I mean, it's not being suggested, I don't think, correct me if I'm wrong, that we might say we'll take each of these torts separately and consider the applicable law for each of them independently.
Well, my lord, it would be unremarkable to have a case in which different aspects of the claim and different allegations were adjudicated upon under different laws. It would be, we would say, surprising in this case because the core elements of each of those torts are common: intent, knowledge, acts and omissions linked to the damage.
Yes, but there is something, you might say, very different about, someone might argue, about misfeasance in public office. I mean, its history is such that you might say, well, it's a specially geared public law tort, let's say.
Yes.
And you might find it, you know, the fact that you, in a sense, placed your case on it might indicate that that has to be taken into account, at least for that tort.
Yes, my lord. And that's, I mean, that is a point we actually make in our printed case at paragraph 57, because of the particular nature of the tort of misfeasance. That's page 101. Because of the particular nature of the tort. Now, it could be that as a result of that, one splits off the applicable law. It could be that the court says, well, because that provides a helpful analytical gateway into what the appropriate law is for the remaining torts. But, my Lord, I don't demur from the... I'm so sorry, my Lord.
I'm so sorry to interrupt, but why does one make that linkage? I mean, the forum is the English court, so there's not a problem of being in different forums. I mean, English courts are used to determining what law to apply and then applying it, whether it's English law or foreign law. If the argument in relation to misfeasance in public office shows that there isn't a foreign law analogue, and that is to be taken as a factor pointing to English law applying to that, why isn't the result that one applies English law in relation to that, but maybe foreign laws in relation to the other torts?
Well, my Lord, I do accept that it would be a possible outcome and a permissible outcome.
Right.
I mean, I would say...
I was asking for a more positive submission. You seem to be saying that you could use, if you like, misfeasance in public office as an anchor that then drags the applicable law for all the other torts into England.
Well, my Lord, the reason why misfeasance in public office, seen through the prism of Section 12, is one that we would say so obviously should be before the court in a case like this, relates to, is not least to who the parties are, which is part of the test under Section 12. So it's the defendants acting in their official capacity as public officials for their perceived benefit of this country, but acting in a way that was patently, we would say, unlawful, and therefore it'd be entirely appropriate for a misfeasance in public office to govern the calibration in civil law of whether they committed wrongs or not.
Right. I follow all of that in relation to misfeasance.
Yes.
Maybe you're not making the submission that if we went for English law is applicable in relation to misfeasance, but other laws are applicable in relation to the other torts. Maybe you're not saying
well, my Lord,
anything follows from a view taken in relation to misfeasance for the other torts. Are you? I'm asking, and if you are, can you explain to us why?
The reason why it helps is this. There are, of course, features to misfeasance, which I've just identified, that separate it in nature and quality from the other torts.
But just to be clear,
yes.
So you are submitting, is this right, that if the analysis in relation to misfeasance in public office is that English law should be taken to be the applicable law, that has a spillover effect in relation to the other torts as well?
Yes, but can I explain why?
Yes, please. Yeah.
Because I'm not saying simply because you've identified that one tort is appropriately dealt with under English law, it must mean for sort of case management reasons or any other reason that the others should follow. The reason why it does here is because the essential ingredients of the tort of misfeasance, which compel, we would say, the court to apply English law, are all the same, bar one aspect, are all the same constituent elements as the other torts on which we rely. Now,
right, sorry, just on that. If that's right, why doesn't the sort of anchoring effect work the other way around? So why couldn't one start with say, trespass to the personal negligence, say that there is an analogue there, and working through Section 12 and Section 11, it's a foreign law, and say, well, we've got to treat them all together, so that's the anchor. And so even if there are unusual features of misfeasance, we'll not treat those as determinative.
I'm so sorry, Molly, it's my inelegance. I'm not suggesting that simply you get to the application of English law to all the other torts simply because you think English law is the appropriate one to govern misfeasance. I'm not saying that happens as that operates as a matter of principle. It just operates as a matter of fact in this case, because it's the same underlying ingredients in the tort of misfeasance that compel English law to apply, bar one aspect, as it is with all the other torts. That one aspect is the kind of the public law nature of the tort of misfeasance, which is relevant in the conflict of laws test, because Section 12.2 directs us to look at who the parties are. So it's a relevant consideration. That separates it.
It's your pleading in 46B, isn't it? The acts and omissions on page 291. The acts and omissions were committed by those public officers in performance or perpetual performance of their official function.
Yes.
That's what distinguishes that one.
It does. Although, my Lord, for the purposes of the test under Section 12, that is not an irrelevant consideration when we come to look at the other torts, because one looks at who the parties are, the capacity in which they're sued, the nature of the claim. But it is particularly apposite in respect of misfeasance in public office. So, I'm so sorry.
I'm so sorry, and it is my fault, but I'm a bit confused by what you are submitting in relation to this. You said there isn't a similarity in principle, it's just illuminating on the facts. I understood you to be somehow saying that if you can get home English law on misfeasance in public office, that meant that should count as somehow a factor which means that balance in relation to the other torts, the applicable law in relation to the other torts, is affected and helps you get home in relation to them. Are you saying that?
My Lord...
Are you saying it, first of all?
Well, I think, my Lord, there's a... yes, but... And can I explain it? Because it's my fault, my Lord, for my inelegance, not obviously not yours. As a matter of principle, just because you have concluded that one of an array of torts is governed by English law does not of itself compel you to conclude that the other torts must be governed by English law. And the same principle applies in reverse. Just because foreign law applies to one tort, clearly, does not mean that foreign law must apply to all. You still need to go through the statutory test. Now, as it applies to this case and misfeasance, a court could conclude that misfeasance in this case is of a special character and that it is substantially more appropriate that that English law govern it, and it proceeds before the court. And it could do that because it could identify special features of the tort of misfeasance. And we've made submissions to that effect in our printed case. But it is also, in this case, we would say, as a matter of fact, on the pleadings, that many of those core essential elements of those torts also form the basis of the other torts. Because the core elements of the tort of misfeasance, beyond the kind of nature of the tort itself, are all present there. The intent, the knowledge, the acts and omissions, the causal link with the damage. So, my Lord, as a matter of... So I hope I've answered my Lord question. As a matter of principle, the mere fact that you start off with one tort unquestionably being governed by one law does not mean of itself that the others must be.
But are you then saying, and then look at the common elements, the core common elements, and that shows that in relation, since you've got, let's say, a view about misfeasance in public office being governed by English law, there are these core elements that should lead to the conclusion that in relation to the other torts, the applicable law is English law.
On the facts of this case, yes.
Right. So then I ask my question, why doesn't it work in reverse? If you're using the core common elements, starting from misfeasance, to pull the other torts into English law as applicable law, why wouldn't one look at all the other torts and started with them, let's say, I'm not suggesting this is a view, but just for the purposes of argument, say that in relation to them it was the law of one of the 6 countries. Why then doesn't the gravitational pull work in the opposite direction, so that you say that the applicable law for all of them is going to be the law of the 6 countries, and if that happens to mean that you don't have a cause of action for them because there isn't an analogue, well, we know that happens in complex cases a lot. Yes,
because in those circumstances, the one difference I'd rely on is the kind of constitutional nature of the tort of misfeasance, and that's the kind of value-added point that you get beyond the other torts.
I'm not sure that's, if I may say so, answering my question as to why there isn't a gravitational pull that works in the other direction if you're working on this theory that there is a gravitational element which arises from the core elements in all of it.
My Lord, if all the kind of core common elements of misfeasance common to the other torts, all pointed towards a foreign law, then of course that would be a matter that could be prayed in aid by the appellant here as saying why that dictates where you get to on misfeasance. Of course, what we would say is if that were the conclusion that the court had reached, contrary to the submissions I'm about to make, if that were the conclusion, there is nevertheless something within misfeasance that compels a different result.
As I understand your case as expressed in your written case, yes, it is that this is one of the factors relating to the parties which must be brought into consideration in carrying out the Section 12(2) analysis.
Exactly, my lord. Because it's the relationship of the parties is one of the matters that, in particular, one must have regard to when determining the connection.
And just as damage may be a factor which is relied upon by the defendants, yes, and where that may have occurred, this is a factor upon which, as I understand your written case, you rely.
Yes.
But on the two separate points here, one is the defendant is a public authority, and that is a factor that, according to your submissions, we should take into account, yes, the nature of the party. But there's then, I think, a discrete point about the tort of misfeasance in public office, because as I understand it, you are making a point that is a distinctive type of tort because of its public law history and constitutional significance. And I think that's the second point that we're really grappling with, because your first point applies across the board. We've got a defendant who's a public authority. It's just as, yes, important in negligence as it is in anything else that the, yes, defendant is a public authority, yes, if it's regarded as a relevant factor. But as I understand it, there is a distinct, difficult question, yes, about what we do about misfeasance in public office.
Yes. You know. And I think, my lord, the answer to that lies in the phrase substantially more appropriate. So that when you consider the connections, including who the parties are, what it is they said to have done, which must include the capacity in which they have said to have done it, it's substantially more appropriate to apply the English law of misfeasance in public office.
And on top of that, and second, in response to the question from my Lord Burrows, you rely upon the fact that there is no equivalent,
yes,
wrong under the, yes, under the law of whichever jurisdiction these harms may have been inflicted in.
To deal with the tortious consequences of a deliberately unlawful act by the state, designed to harm an individual.
Yeah, well, speaking for myself, I have some difficulty with that position, because it's often, just to repeat the point, it's often the case that one identifies the applicable law and then it turns out actually you don't have a cause of action under that law because you don't satisfy all the criteria required to make good a claim in that law. But nonetheless, that's the applicable law. The fact that it's that applicable law just means that you lose. So, so how does it work when you say, well, there's no analogue of misfeasance in public office? I mean, there clearly are torts in relation to protecting people against personal injury. Why does it make such a big difference that there isn't an analogue for that particular way of protecting someone in respect of personal injury? That you say, well, because there isn't an analogue, therefore the applicable law cannot be that of a foreign country.
Well, because, my lord, we went through the prism of whether it's substantially more appropriate to apply English law, the fact that there may be, to determine the issue, so the issue of liability, the fact there may be no other law that properly encapsulates the heart of what it is they have said to have done wrong and the capacity that they did it is a relevant factor.
If I understand your case, in addition, you say that this is one of those features because of the particular circumstances of this case.
Yes.
In which, so it is alleged, a person has been moved from jurisdiction to jurisdiction so as to be out with the law.
Yes.
It is appropriate to bear that in mind in carrying out the Section 12 exercise as to whether or not this is the law of this country is the appropriate law to apply.
Certainly, my lord. And where I'm moving next, so that you have it, is I'm going to next move for the particular limbs in the statutory test to drive home that point, not only in respect of misfeasance, but in respect of all of the torts.
Just before I'm sorry, I realise you want to get on, but and I'm just going off misfeasance in public office now. But I am just asking the question: do you also plead conspiracy in the foreign laws?
Well, what we don't do, my lord, is do a kind of within the pleading say this is the foreign law equivalent of conspiracy, this is the foreign law equivalent of trespass. What we say is, looking at the nature of the wrongs that are alleged here, these are the provisions of the civil laws of these countries that would give rise to liability. So we're not doing that sort of.
No, I realise that, but I've got to be able to see somewhere equivalent to conspiracy, I think. And you may say, well, that is covered. I'm just not quite sure where in some of these.
I didn't think it was. So take page 301, Polish law. At a quick glance, it doesn't seem to be conspiracy.
No, I mean, this takes us slightly back to the discussion we were having yesterday about are you analysing under sections 11 and 12 like for like provisions, or when one talks about tort, are you really just trying to work out what the essence of the dispute is, what the core components are, and work out which country, through the prism of section 12, which country's laws are the most appropriate one to apply. It doesn't really matter that it's a kind of direct analogue or not. The laws of the foreign country dealing with that complaint are the laws of the foreign country.
Right, but we've had quite a long debate in which you were making a point about there's no direct analogue to misfeasance in public office. But I'm assuming from what you've just said that you're not making the same point about conspiracy.
No, and I mean the points I was developing in misfeasance were particular about the particular importance of misfeasance as well.
But it may well be that your pleadings at the moment don't actually, in respect of foreign law, appear to plead conspiracy.
No, but you want, again, my lord, I'd say with respect from a private international law perspective, it's not a question of having to identify mirror torts or mirror dealings, because most civil law systems will be operating an entirely different system and an entirely different understanding to what gives rise to civil liability to our own.
Entirely, but not even getting the general picture that includes conspiracy is my point. So, I mean, when you look at the US, you've not got conspiracy down, for example. Well,
we have if you look at paragraph 82, I suppose we do have a kind of a common design to participate at 82A, page 304. 82A, each of the defendants are liable to the claimants particularised as a result of their participation in a common design with US officials. But
your approach is to say, on the assumed facts, under these foreign legal systems, there would be liability in these various ways. And
yes.
You don't seek to equate them, and that seems to me perfectly appropriate.
I mean, otherwise you almost reintroduce the double actionability rule through the back door.
Quite.
But presumably, in order to see whether it's appropriate to, as it seems to me, characterise the foreign law as doing broadly the same thing as the English law, you need to find the foreign law which is directed to protecting the same interest of the claimant as would various forms of English law. Is that a fair way of putting it?
Well, yes. I mean, protecting the interests of the claimant perhaps connotes a kind of a jurisprudential basis that would certainly exist in English tort law, but might not in those foreign laws. I mean, ultimately, it's whatever the provisions are of that foreign law that gives rise to liability. And that's why, if I may, the points I was trying to make yesterday about the kind of underlying principles and the need to look for the essence of the complaint when carrying out the comparative exercise under Section 12, we would respectfully submit some value that you look for the intrinsic nature of the complaint.
All right. I can understand you're concerned about time pressures. Yes, we must let you get on.
David, can I ask one last question? Just before we move completely away from misfeasance, can I ask what do you say about Section 14 in relation to misfeasance? So insofar as it said that what's really important about misfeasance is the English public law dimension of it, might it not be said that Section 14 makes allowance for that to be factored into an assessment of applicable law, rather than trying to deal with it under Section 12?
Yes.
Because Section 14 is looking to principles of public policy, and if it said, well, it's very important as a matter of English public policy that English law should be applied to English officials, wouldn't that be the place to deal with that allegation?
Yes, my lord, I don't think I could rely on Section 14 for those purposes, because Section 14 is addressed to the application of the foreign law being contrary to public policy. So I couldn't say, so I'd have to identify the provision of foreign law whose application is contrary to public policy.
But why couldn't it be said, generally, foreign law will apply in relation to these torts, but for this tort, it won't apply for this reason of public policy, and so that leaves you with English law being applied?
Well, it's not the application. I mean, so, my lord, we're on page 424 for
yes, sorry,
Section 14. So nothing authorises the application of a law of a country outside the forum if it would conflict with principles of public law.
So we're presupposing a situation where applying sections 11 and 12, one, subject to any other argument, concludes foreign law applies. But then it's said, but there's this very important constitutional dimension so far as the English law taught in the guise of misfeasance of public office arises. And therefore, so far as that tort is concerned, one cannot treat, to that extent, the law of a foreign country applying, which leaves you applying the English tort, potentially.
Well, my lord, I could see, if I may say so, how that might work. Can I? And I can see how it may avail my client. But can I just, because it's an important point, just kind of at least ventilate what might be said in opposition to it, and say that my lord has it, which is that certainly as previously understood, and of course Section 14 reflects the common law position to a large degree beforehand, from Catamol and Oppenheim through to Q8 Airways, etc., in which the question as to disapply a foreign law, I beg your pardon, the question of public policy has always been seen in the context of should you disapply a given law that would otherwise govern the claim. When one looks at the application, would the application of that law be contrary to public policy? So that's how Section 14 has been interpreted to date. And my lord,
that's what it says, and that's what my lord is suggesting would happen. That if, applying 11 and 12, you come to the conclusion that it's the foreign law, or one of the 6 countries that applies, that result might be reversed by the operation of Section 14.
Yeah, for the tort of misfeasance in public office. And we've already discussed that it's perfectly possible for English law to apply in relation to one bit of the claim, but foreign law in relation to other bits of the claim. Anyway, that is indeed my question.
But it's not a point for today, because we're not concerned with Section 14.
You're not concerned with Section 14.
No, but I was asking for assistance as to how what you're emphasising is this constitutional element within misfeasance might be accommodated, just as a matter of principle. I appreciate Section 14 is not before us directly, within the scheme of the Act.
It still might come back to substantially more appropriate, because if, for instance, the foreign law that's only applicable is negligence, or the equivalent of negligence, the analogue of negligence, and you say, well, we're going to disapply the law of negligence insofar as it affects misfeasance in public office, but otherwise apply the law of negligence of the foreign country, you then get back into substantially more appropriate, because you have the potential for all sorts of difficulties there, applying 2 legal systems.
Well, Potentially, my lord, but I mean, I think we'd say the
Sorry,
lodestar here at every
adopting that
stage.
or not? If you are,
Well,
then
I
I'll
know-
ask you a question as well.
I know I mean, you must, of course, move away from foreign convenience when you're under substantially more appropriate. And perhaps it's unfair to put all these questions to you, but I'm not convinced at the moment that just because you apply Section 14, you move away from the substantially more appropriate test.
Oh, my lord, the tests in Section 11 and 12 have to be applied for what they are.
Yeah.
My Lord Sales's point as to whether or not you could carve out misfeasance through the operation of Section 14.
Yeah.
Could I just give my lord, as my lord...
Well,
Jones
just
said,
before you do, can I just make, if I may, my sort of observation on what was being put to you? I mean, you can have separate causes of action governed by different forms of law, and you can rely on each of them. It doesn't matter if they overlap to some degree or don't. If you win on one, that's great. You've won on that one. There's no reason why, just because you've got one cause of action governed by one particular law, you can't have another cause of action governed by another particular law. So I don't follow. My comment was I wasn't following. If you were going to accept the suggestion that just because one's dealing with misfeasance in public office being governed by English law,
yes,
which I'm asking you to suppose,
yes,
whether that has any knock-on effect in terms of the Section 12 balancing exercise.
My lord, I'm not sure that it does on this case. I'm going to come to the balancing exercise directly in a moment, if I may, because, I mean, it's going to be my primary submission that, interesting as the discussion is about whether you can carve off misfeasance in public office, actually, when you apply the statutory test under Section 12 to the facts of this case, there's one answer which is uniform for every aspect of this case. But can I just, before I just depart, conscious that Section 14 isn't before the court, but I hope in a way that it is helpful. The one difficulty with the proposition that you can carve out misfeasance through Section 14 is that Section 14 has been understood to date to apply simply when you look at a provision of foreign law and say, would its application be repugnant to policy? Can I just give you, taking from there's a passage cited in the Ramatullah case of Lord Sumption in Cox against Ergo. I'm not going to against Ergo, and that's cited at paragraph 40 of the judgment of Mr. Justice Turner, page 633 of the authorities. And it's Lord Sumption saying that the provision is limited, there's a limited saving through the public policy of the forum only in cases where a specific foreign law was found to be repugnant to the policy of the forum. Now, I appreciate that my Lord Sales's point is a slightly broader one, but I hope those answers at least...
Perhaps we should prolong this debate since we don't have Section 14 directly before us. I appreciate that.
We think we should give you a straight run. That doesn't mean we're not going to ask you any questions.
I suspect that might be right.
But you've got
Not sure what that means
50
then,
minutes left.
Yes. I'm going to make 6 points about the plain application of Section 12 to this case. And my first point concerns the first limb of the comparative test under 12.1a, which requires identifying the factors connecting the tort to the countries in which the damage was sustained. And here, there is only a single connecting factor, that the personal injury was sustained in at least some of those countries, albeit at the hands of agents of a third-party state. So the only thing when one comes to 12.1a that is of significance that links the tort to the country whose law is said to apply is the factual predicate for the general rule in the first place. Now, I don't say, of course, that that factor is irrelevant or that it can be ignored, nor did the Court of Appeal. In most personal injury cases, the inquiry normally begins and ends at Section 11.2a. But it is relevant, the fact that that is the only factor linking, when one comes to the qualitative assessment in Section 12.1 of the significance of the factors connecting the tort with the country. And it also is relevant when then comes to the next round of qualitative assessments, which is whether it's significantly more appropriate to apply a foreign law. So the only thing that gets us in to the general rule is the singular fact. Nothing else goes into the pot in its favour when one moves from section 11 to section 12(1).
When you say the foreign law here, for this purpose, we're looking at English law.
Yeah, the 6 countries.
The law of another country.
The law of another country, yes.
Which is for this purpose English law.
No,
Under section 12.
Under 12(1)(a), though, you still go back, my lord, to say that the first limb is that you look at the law that would be applicable under the general rule.
Yes, I understand that.
I'm so sorry. So I'm addressing that at the moment to say that when one looks, as you must, under section 12(1)(a), at the significance of the factors.
I don't want to hold you up. Your submission is that the one factor here linking this to those different jurisdictions is damage.
Yeah, that's it.
I understand that submission.
And that's relevant because you're asked to look at significance of the factors under 12(1)(a) and appropriateness in the terms of the general.
Sorry, just on that.
Yes.
It's not just damage, is it? It's the fact that the acts were carried out by persons within those jurisdictions.
Well, I suppose they're so close together. I mean, yes, my lord, I accept that. The damage was sustained by the acts by the torture in those countries.
Committed by agents of a foreign state.
Yes, of a third-party state.
It had absolutely no connection whatsoever to the sixth country.
Well, that takes me to my second point.
Yeah.
Because you're asked to assess the significance of the connections between the tort and the country to whom the general rule applies. So that obviously means not only those factors that strengthen that connection, but those that are capable of attenuating that connection. And here, not least seen through the statutory prism of section 12(2), there are a host of factors that dilute the link, the strength of the link. The most obvious of which are these. The claimant had absolutely no idea in which country he was being held and in which his injuries were sustained, where the damage was located. He'd been taken by force against his will to all of them, and their location was deliberately kept secret from him as part of his mistreatment, part of which was designed to disorientate him. And of course, his entry into those countries was not in any sense under cover of law. No passport was being stamped. In contrast, for example, with an extradition case or a deportation case, in which the links to the receiving country would be clear. Furthermore, the defendant was at best indifferent to the countries in which the damage was sustained, if they knew of it. Now, I can assert that with confidence in this case, because if you know that repeated communications were sent for years after they realised that he was being treated at a level at which 98% of US special forces would crack, but continued after that knowledge to send letters, then it is obvious they are indifferent to where he's being held in a secret prison. The injuries were sustained in what were, as a matter of fact, law-free enclaves of foreign states operated by non-national third parties who had no direct involvement with those host nations. They were selected simply because they would permit secret prisons in which torture could be committed with impunity. No one, for a moment, would have thought that local law would apply to govern their actions. That's the point. You can't torture in detention centres governed by law. And indeed, that the intention was to evade law is reflected in one of these features of this case, which is that when the CIA were holding Mr. Abu Zubaydah in Guantanamo, and the US Supreme Court were going to consider the question of habeas expensing to Guantanamo in the Razor case, they rendered him out of Guantanamo to avoid the implications of it. Furthermore, whilst the damage was sustained in at least some of those secret prisons, the effective cause of that damage in these tort claims, i.e. the ones the court must consider under Section 12, as pleaded with the acts of the defendants here.
Sorry,
With
what?
the acts of these defendants here. That's the effective cause of the damage complained of in this case. It's not said that they are vicariously liable for the CIA. They're liable because the questions that they sent here, with the intent and knowledge that they had, were designed to elicit answers under torture. And our case is that they did. What is more, that damage which was instigated by the defendants, was for the perceived benefit of the defendants in this country. So there's a direct link between the element of the tort, which is the damage, and the case, the tort, the links with this country. It's a direct link on this pleaded tort, on these pleaded torts. And those factors, together with the others that we set out in our printed case, demonstrate why this case is as far removed from most personal injury cases in which the reasonable expectation of the parties is always, almost invariably going to be the law of the country in which I sustain my injury is going to govern the dispute. It's as far away as that. It's as possible, it's conceivable to imagine. Can I take my third point, which is to look at the next limb of 12.1b, which are the significance of the factors connecting the tort to this country, again stressing the word significance, and again stressing the particular factors to which one must have regard in section 12.2. The core elements of the complaint said to give rise to the liability of these defendants. The tortious conduct complained of all took place here, and it was undertaken in the capacity as officials of the United Kingdom.
How can you say that all of the core elements of the tortious conduct took place here?
Because what I mean by the tortious conduct in this context are the acts and omissions of the defendant. That was there. That was. Now, my lord, I accept, and I don't want to rehearse yesterday's argument that one would also look at damage. I mean, that gets us within the general rule, and I've made my submissions that there is nevertheless a clear causal link, and therefore significant connection between the damage and what was done here. But my lord, I don't mean. I'm so sorry. It might be.
Well, one of the factors which connects the tort with the 6 countries is that the damage was sustained in those countries.
Yes.
And that is a constituent element of the torts that have been alleged.
Yes.
And so, whereas you can say that a lot of the tort was committed in this country,
yes,
I just doubt whether you can say that all the tortious conduct took place here.
I'm so sorry. My lord's absolutely right, and I was using that as lazy shorthand for the kind of acts and omissions.
Yeah.
So the acts and omissions for which the defendants in the parties to the claim will have their liability assessed on, or stand and fall on what they did and what they didn't do, all of those took place here. And in argument yesterday, Sir James sought to downplay the significance of what the defendants had done in the grand scheme of things, characterising it as no more than pressing send on a keyboard. And my lord, that is we would respectfully say, a fundamental mischaracterisation of the torts advanced in these cases. And it's misplaced one under the statutory scheme. The connections between the torts, the elements of the torts that focus on what the defendant did and did not do, their acts and omissions, with this country are multiple. It must be assumed that this is where the decision to send questions was made, notwithstanding actual knowledge held institutionally here that the respondent was being held in secret and being tortured. In other words, all the elements of intent and knowledge are connected to this country. Those questions were likely developed and drafted within a mile of this court on multiple occasions. Insofar as consideration was given as to whether it would be appropriate or lawful to seek answers from a person detained being tortured at all, those were discussions and decisions likely made here. To similar effect, discussions and decisions leading to a decision not to seek assurances would likely have been made in this country. This is, of course, the country in which the questions were dispatched from. This is where the relevant information extracted under torture and mistreatment would have been sent. This is where that information would have been analysed. All of this done by UK officials acting as such in belief they were serving the interest of this country, all of whom would have known that their acts and omissions would be subject to at least some elements of the law of England. As we set out in writing, although not determinative, but relevant, is the fact that the acts and omissions of the relevant officials, if made out, would amount to certainly the crimes of misconduct in public office, and also an offence under Section 134 of the Criminal Justice Act 1988, which is the extraterritorial provision in respect of torture.
Sorry, the section is which one?
Section 134 of the Criminal Justice Act 1988.
Doesn't need to be extraterritorial, does it?
Not for the nature of torture, but yeah. It's the express provision that expressly permits prosecutions for torture committed overseas. There was an Afghan warlord case, the most famous one, I think, tried before the Bailey. But my lord's absolutely right. Just didn't actually need that. But that's what it is, and that would, if the facts are made out in this case, be applicable to the relevant officials in this case, as would data protection laws that apply to the security services. So all of that would have been placed. And we say, having regard to those criteria, so to those connections between the tort, both the acts and omissions, and the causal connection to damage, and the intent, those connections between the tort and this country, and the nature and capacity of the parties, that the connections with this country are compelling. Also, we submit that many of the submissions advanced by Sir James about the relatively small part played by the appellant in the mistreatment are best of marginal relevance to the analysis under Section 12. The primary focus must be on the torts alleged against these defendants. They are sought to be held liable for tort for what they did and what they did not do, and for the direct consequences of what they did and what they did not do. This is not a claim against the CIA generally, or indeed at all. It is not a claim in which the defendants are being held liable for anything other than the consequences of their tortious conduct. And the danger of seeking to contextualise this claim in the broad context of what the CIA were doing generally at the time, and in particular to Mr. Zubaydah, is that you fall into the errors that the Supreme Court corrected in VTB. My Lords, my fourth point is that the balancing exercise, the evaluative balancing exercise, is readily met here by a simple evaluative review of the competing strength of the factors under 12.1a and 12.1b, seen through the prism of 12.2. It leads in our submission to only one answer. We are entitled, we say, to ask rhetorically that if it's not more substantially appropriate to apply English law than, say, Moroccan or Lithuanian law here, then when would it be? On the defendant's case, all we have is the locus of the injury, and they submit you need to see this as part of a wider CIA programme relating to Mr. Zubaydah. Of course, the significance of the locus of the injury is relevant. Of course, the fact that those injuries were inflicted in those countries is of relevance. But those factors are attenuated when just seen in isolation under 12.1a, in this case in a way that is very difficult to conceive could be more stark than any other. And competing with that are the factors under 12.1b, tying these torts to these parties very closely to this country. And that is why we submit it is substantially more appropriate to apply English law to govern the acts and omissions of these defendants in these claims, the damage they are said to have caused, than it is for the law of any of those 6 countries. My Lord, my 5th point, in terms of time, I'm just going to state it and give you some references in our printed case. But it's that the correctness of our analysis we would submit can be tested by the absurd outcomes that would result if the appellant submissions that the locus of the injury in this case is paramount and determines the applicable law in and of itself. And we set out where that would take us between paragraphs 65 to 75 of our printed case, tying it in, not least, with examples given by the Law Commission of when it would be inappropriate to apply the law under the general rule. I was going to then turn to my 6th point, which addresses the cases relied upon by the appellant, who rightly acknowledges that they don't determine any result in this case. And presumably they would therefore accept that whether or not the Court of Appeal interpreted them correctly, or that we say they did, wouldn't have impacted upon the outcome of their analysis. It doesn't vitiate their decision, even if they failed to interpret cases that they correctly did not think dictated their outcome.
Was a similar concession made in the Court of Appeal in Belhaj that the laws of Malaysia and China applied?
There was a concession to that effect, and I'm going to turn precisely to that, if I may, my Lord, in just one moment. Sir James rightly departed from the submissions below that the case of Al-Jeddah was of assistance. That's a correct concession in circumstances in which the case of Al-Jeddah concerned the detention of Mr. Jeddah in Iraq. He was born an Iraqi national, spent most of his life there, played for the national basketball team. He returned to Iraq, was suspected of involvement in a terrorist activity in Iraq. He was detained throughout in Iraq, and most pertinently, he was detained under colour of Iraqi law throughout the period by British troops who were there at the request not only of the Security Council but of the sovereign government of Iraq to help maintain and secure security in Iraq. And that is why Lord Justice Brooke in the Court of Appeal concluded that pretty much at every turn this was an Iraqi case. For your references, paragraph 101, page 461.
Sorry, paragraph
101 at page 461 in the judgment of Lord Justice Brooke, and also paragraph 106, page 462. in the House of Lords, Lord Bingham not simply agreed, he wholly agreed with Lord Justice Brooks' analysis. Just for your note, paragraph 43, page 488. I don't know if it would be helpful. All the other members of the court agreed. Belhaj.
Sorry.
Can I turn to Belhaj?
Belhaj, yeah.
As we set out in our printed case, paragraphs 111 to 113, page 124, it's a case that again can be readily distinguished. The case concerned the treatment of Mr. Belhaj and his wife, Miss Boucher, in 4 countries and upon a CIA rendition jet. There were 2 parts to the allegations against the defendants. The first concerned their role in a plan to tip off the Libyan regime as to where Mr. Belhaj was being detained in Malaysia in order that he could be rendered back to Libya. It was, in essence, a common design to achieve those aims together with the Gaddafi regime, who in turn went to the CIA to effect it. And the second part of the claim concerns visits by UK security personnel to Tripoli, where Mr. Belhaj was being detained, in circumstances in which it was alleged they knew he was being tortured. Can I just identify 3 particular distinctions between Belhaj and this case? As my Lord Stevens has identified, in Belhaj, the claimants conceded that at least part of the claim would be governed by foreign law, in particular the laws of China, where Mr. Belhaj was initially detained, and Malaysia, where he was detained for about a week. And this was because this concession was made because it was accepted that the claimants were probably detained there under the colour of local law. In particular, in Malaysia, he was held under immigration powers in an immigration detention centre before being placed on a plane to Bangkok. And both the High Court and the Court of Appeal thought this was a significant concession. Where a state detains an individual under its own national detention laws, that might be thought a very strong factor linking detention to that part of to the laws of that state.
And where do we see that concession recorded?
I'm going to give you...
144, I think.
It's 144 of the Court of Appeal, 124 as well of Mr. Justice Simon, page 545.
Sorry, there's references again, please. Court of Appeal, paragraphs 124 and...
No, it's 144, I think, my Lord, at page 611.
611, yes.
And paragraph 124...
At page...
A first instance at 545.
Right.
And as you'll see in the first instance judgment, flowing from that, His Lordship, Mr. Justice Simon, said that the real issue was not so much which law or law applies to the alleged torts, but which side should plead the applicable laws first, a point that my Lord raised yesterday. So that's an important distinction.
I think it may also be helpful to have in mind in the Court of Appeal paragraphs 153, 154 and 155, where that concession certainly featured in the reasoning of the court.
Yes, thank you, my Lord. And I hope we deal with those paragraphs, and I'm sure we do it in the written case, but my Lord's absolutely right, and I do rely on those. And that's one important distinction with Belhaj. The other important distinction is that the claimants also had very significant connections with the country where most of the harm was inflicted and which formed the main focus of the claim. Mr. Belhaj was a Libyan national and a prominent public figure in Libya. Indeed, he became the governor of Tripoli and was a high-profile opponent of Colonel Gaddafi. Thus, in respect of Libya and the claims of seeking to obtain intelligence off the back of torture, the context was that he was a Libyan citizen being held in Libya by Libyan officials in a Libyan detention centre, indeed a Libyan detention centre that was purportedly operating under the colour of Libyan law. Indeed, Mr. Belhaj, as it happens, was even afforded a trial in detention in Tripoli, albeit one of standards that would have made Field Marshal Beria blush. But that is a very important distinction. And the third is that for the discrete purposes of a Section 12 analysis, not least under 12.1a and 12.1.2, there was a far closer connection between the defendants and the countries to whom laws whose laws were deemed to apply. My learned friend referred yesterday to the fact that in Belhaj, the defendants were alleged to have been responsible for the claimant's rendition to Libya, and he says that the application of foreign law is therefore a fortiori here, where no similar allegation is made against the defendants. But this distinction we submit actually inures in favour of our position on the application of Section 12. In Belhaj, the claimant's presence in Libya was a direct consequence of the deliberate decision by the defendants to procure their rendition there to that country. The connection between the tort allegedly committed by the defendants and the country where the injury was inflicted, Libya, was therefore a strong one. And taking those three factors together, one can, we submit, well understand why the courts in Belhaj took the view that if the liability for the defendants for detention in China and Malaysia was agreed to be governed by those local laws, and where detention in Libya was in fact governed by local law, that it wouldn't be substantially more appropriate to apply English law to events in Bangkok, where Mr. Belhaj was present for about a day or so, or a CIA chartered jet, where he was held for a matter of hours. Belhaj is not, we submit, authority for the proposition that the liability of His Majesty's government for seeking to extract information from those it knows are being tortured overseas is governed by the law of the country who has agreed to accommodate the secret prison of a third-party nation.
Have I correctly understood that in Belhaj the issue on this particular part of the case was whether or not the claimant was required to plead out the foreign law which the claimant had accepted was applicable?
My Lord, that was an issue, but Sir James was right yesterday to tell you that the court, Mr. Justice Simon, did tackle, nevertheless, the issue of what law governs the dispute. What his lordship held was that effectively, not least because of the concessions, the real issue that he had to determine was who goes first, which is a matter to which this court has returned again in Brownlee to consider. And that was the thrust, I think, of the arguments before the Court of Appeal, as it was before Mr. Justice Simon. But, my Lord, his lordship did, though, address the test under Section 11 and Section 12 and did reach a conclusion in respect of what law applied. So James is absolutely right to make that plain.
Mr. Herman, I wrote down and understood you to say a moment ago that Belhaj is not authority for the view that the liability of Her Majesty's government for its role is governed by the law of Libya.
No, I'm so sorry. It's governed by the law of the country who has agreed to accommodate the secret prison.
Thank you. Thank you.
Ramatullah, which is the first instance decision of Mr. Justice Turner, the case settled before the question of permission to appeal was considered by the Court of Appeal. The facts touched on by Sir James. The question arose as to what law should determine the liability for a failure of the defendants to ensure that the claimant wasn't being mistreated in the decade in which he was held and tortured in a secret prison in Afghanistan, having been unlawfully rendered there, contrary to the Geneva Conventions, by the Americans. And liability was said to arise because of a quadpartite memorandum of understanding signed in Qatar between the United Kingdom and America and two others, and it arose out of that. The Court of Appeal Lord Justice Mayall's placed limited reliance on the first instance decision, and you can see the reasons why between paragraphs 47 and 49, page 146 of his judgment. I mean, obviously, no disrespect to observe that it's a judgment that contains very lengthy citation of authorities and very lengthy citation of the MOU, but we would submit no clear analysis of the two limbs of section 12.1. And indeed, at section 35, his lordship gives a pretty bare conclusion, stating it would be disproportionate to list all the arguments.
What page number, please?
That's paragraph 35. I think that's going to be 144.
144.
And so we submit that that is a case of very limited assistance to you. (143). I'm so sorry. Could I turn then, if I may, to the third part of my submissions, mindful of time, and seek to develop why we say the High Court got it wrong to a degree that justified the Court of Appeal interfering. And we say that the learned judge fell into fundamental error of principle by not securing his analysis through section 12 on the prism of the connection between the torts brought against the pleaded defendants, but rather than examining it more generally in the wider context of the CIA rendition programme as it related to Mr. Zubaydah. And that error, in turn, led to two consequential and independently fatal errors. Firstly, a failure. It led to the failure to properly calibrate the significance of the factors under 12.1a, attenuating the links with the law of the foreign countries. And then, in turn, leads to his third error, which he failed to properly calibrate the connections between the torts and this country. Well, the key part of his lordship's analysis begins at paragraph 49 of page 168. He starts quite correctly with, in his analysis as to 12.1a, of the fact that the damage was sustained here and that the general rule applies, subject to displacement. And then between 50 and 57 concludes that the factors relied upon by the claimants did not materially dilute or attenuate those risks. His lordship held that the fact that the claimant was held in secret prisons outside national legal systems did not in any material way attenuate the connection between the tort and the country in which damage was sustained.
Which paragraph?
This is 50. This is 50, for example, and it's a theme that reappears throughout 50 to 57, my lord. This whole section of the judgment we respectfully submit bears careful scrutiny. His lordship also appears to conclude that because laws nevertheless operated outside the walls of the secret detention centres, those laws had a material connection with the tort.
Where does he say then?
So, my lord, if you look at 50, so you see that submission is made to downplay the significance of the factors under 12.1a. The black sites within each of the 6 countries were deliberately used by the US in order to be free to act with impunity, irrespective of the laws of the country in question. His lordship said, well, that may have been the result in practice. At the time the torts are committed, it does not in any sense mean that the laws of the country in some way cease to exist. On the contrary, each had laws which would on their face prescribe treatment. And there's a comment to similar effect at 56. And indeed, at 57, his lordship holds that this case is far removed from the type of legal black hole that would arise if a host country, had no laws or had laws that permitted torture. And that these were factors that undermined the claimant's attempt to try and say that there was an attenuation of the link between the tort of the country. My Lord, and so far as the distinction was drawn, for the purposes of section 12(1)(a), between a secret prison that's in a country that has laws operating outside its walls and one that doesn't, or one that permits torture, is a distinction without any relevance to this case. On any view, this claimant was being held in a legal black hole, a paradigm of a legal black hole, this case. And it must be right that that is a fact that is relevant when one considers the link between the country and the tort. Paragraph 58, again, we're still in section 12(1)(a, page 1. His lordship addresses the claimant's submissions about the relevance of his own lack of control and lack of knowledge about the countries in which he was being held in. And his lordship concluded that that didn't serve to reduce by any material extent the significance of the claimant's injuries being sustained in the 6 countries. No reasons are offered by his lordship for that, and in our respectful submission, it is plainly wrong. At paragraph 60, his lordship deals with the significance of the fact that the defendants might not have known or did not care about their location at the time the questions were sent. And his lordship concludes that has no material impact on the test under section 12(1)(a). And the reasons are instructive because they are, although the country selected were incidental to the defendants, they were not incidental to the CIA. And the flaw, we respectfully say, in that analysis is it doesn't engage with the central features of the tort that falls to be analysed under section 12. Including the factors relating to the parties under section 12(2). It's a wider contextualising of the claim for the purposes of the statutory test that has precluded CVTB. And what is more, the fact that the location of the countries was not incidental from the CIA's perspective, as Lordship's finding, doesn't elevate the claimant's presence into those countries into a strong connection with the countries who hosted the secret prisons. At paragraph 62, his lordship turns to the next limit of the test, and 12(1)(b), the connections with this country, and his lordship holds that they are of limited significance, and again, it's instructive to see why, because his lordship said that any provision of information used in interrogation by the CIA was a component in the overall exercise undertaken by the CIA. It was the methods adopted by the CIA in putting the questions to the claimant that are said to have occasioned the physical and psychological harm. Even if, and for the reasons I've given, we'd say that's not the way to look at it. Even if you can take that into account, that has to be a small factor of little weight compared to what the nature of the allegations against these defendants are in these claims, for what it is they have said to have done and what it is they have said to have caused. And the reasons, this all explains the reasons why His Lordship fell into error in analysing the case that way rather than through the prism of the tort as mandated by Section 12. And we see that reflected in His Lordship's conclusion on the balancing exercise, which he draws together at paragraph 69. In which one of the factors he looks at is there that the information came from officials who were here. His Lordship says the significance of this imparting of information in the context of the present claim is limited because it's only an element in the overall treatment of the claimant by the CIA in the 6 countries. So there were, as the Court of Appeal said, 3 errors. One of fundamental approach to the statutory test, which in turn led to 2 additional consequential errors: failure to properly calibrate the test under 12.1a and a failure to properly calibrate the test under 12.1b.
When you refer to paragraphs 58 and 60, where Mr. Justice Lane was talking about no material or reduced to any material extent, reducing to any material extent in 58, and I don't consider this point as any material impact in paragraph 60.
Yes.
Aren't these questions of weight for him? Isn't he just saying, I'm not placing, I'm well aware of them, I'm looking at them, I'm considering them, I just don't think that they have the weight that is being suggested?
Yes. Well, my Lord, there are 2 answers to that. I mean, one is that's wrong if you follow His Lordship's reasoning as to how he gets there, which is he's seeing this through the prism not of the tort, he's seeing this through the prism of the overall operation by the CIA. So his conclusions are effectively tainted by applying the wrong analytical approach. And the second reason is whatever approach His Lordship raised, applied to the facts of that case, that conclusion is just plainly wrong. Completely, we would say, misplaced in the context of these facts to this statute. It requires under 12.2, looking at features, for example, relating to the parties, requires you to focus on tort. To say in those conditions, in respect of a conflict of laws case, it can have limited, if any, material impact because the claimant has absolutely no idea where he is because he's been taken there by secret and tortured, and the defendant didn't care, and that can have no material impact on reducing the links between this country and those foreign countries. It's just plainly wrong. He ascribes it no weight, and that is plainly wrong. Could I move very briefly to the Court of Appeal's judgment? 2 points to address by necessity at speed. The first is whether the Court of Appeal fell into any error by primary reference in its analysis to what the defendants did and did not do in identification of the applicable law. And the second question is to the permissibility of its observations about what's likely to be a live issue at trial and what's not. As to the first point, our submission is the Court of Appeal made no error. The Court was well aware that the place in which the damage occurred was a factor that needed to be considered in Section 12. It was the reason why the general rule applied. There was no possible hint.
Sorry.
That's the reason why the general rule applied. They obviously recognised that, and they also assessed it in the context of 12.1a. But they reached an evaluative conclusion that in the context of this case, when there was nothing really beyond that fact, I mean, they acknowledged it was inflicted by the CIA agents there, but nothing really beyond that, they reached an evaluative conclusion looking at the significance of the factors, the significance of the tort in relation to the country, in relation to the issue, that really what should guide them are the acts and omissions. The prism that should be looked at that is primarily through the acts and omissions of the defendant. They considered that was the most significant, the intrinsic nature of the case. And once they had identified damage and identified that there was nothing else beyond the fact that the damage occurred in that country, there wasn't really much else for them to analyse but intent, where do the acts and omissions occur, what's the causal link with damage from here. I mean, once you've identified that damage as a feature and there are no other real connecting issues, what else is there to do but to analyse it through that prism? And so we say that they conducted a perfectly appropriate evaluative exercise, and one that this court should not interfere with. Could I move then finally to the point that Sir James made yesterday and is also reflected in the statement of facts and issues, whether the Court of Appeal impermissibly sought to take into account what was and what wasn't going to be live at trial. And really just 2 points. Firstly, real care needs to be taken not to elevate what the Court of Appeal said in the opening paragraphs of its judgment into anything other than a broad introductory overview of the nature of the claim and an observation in general and caveated terms as to what was ultimately likely to impact the time of the trial judge. And we can see that, the comment comes from paragraph 13 of the judgment, at page 135. So this isn't in the analysis as to which law applies. This isn't the heart of the judgment. It's under the heading, the claim in this action. And you can see that his lordship states at 13, it was impossible to be categorical about any of these matters at this stage. He caveats by noting the court hasn't received any closed defence, and he does no more than make his observation on the basis of the pleaded facts, which must be treated as correct for the purposes of the hearing before his lordship, and he simply makes a comment. It's not a finding. No impact on his analysis, and indeed, on the basis of the materials that were presented to that court and this court, it's not an unreasonable observation to make. The second point is that in any event, even if, and you weren't shown any passages to suggest that was the case, even if those comments were transposed into his lordship's subsequent analysis of the Act, it wouldn't materially impact on that analysis. The determination of what the CIA did or did not do will primarily be an investigation of the facts. If the CIA did not torture as alleged, then the case will fail on its facts. If they did torture as alleged, and the question will be that posed by the Court of Appeal. What's the appropriate law to govern the actions of the defendants to this claim? One shouldn't have lied, as Lord Clark said in VTB, approving the Court of Appeal, you shouldn't have lied the significance of the tort falling to be assessed under Section 12.
Sorry, you dropped your voice. You mustn't have lied.
The significance of the tort with aspects of the claim that require the most elaborate factual investigation. That's paragraph 198 in Lord Clark setting out the Court of Appeal at page 774 of the bundle.
98.
So it doesn't form part of the Court of Appeal's analysis. It's an observation at the beginning of no legal effect, and it wouldn't in any event impact upon the analysis of Section 12, even if it did that, which it doesn't, and is transported into part of the analysis. So it's a point we respectfully say that takes the appellant nowhere. My Lords...
Sorry, just on that.
Yes.
I may be missing something. Don't the observations in paragraph 14 feed into the section 12 analysis later on?
I'm not certain that's...
Well, no, but my Lord, but those reflect the assumed facts in the pleadings,
Right, okay.
which His Lordship was fully entitled and invited by all the parties to proceed upon.
Yes, I see. Thank you.
There's nothing in there that vitiates His Lordship's judgment.
If we were to come to the conclusion that both courts had fallen into error, what course in your submission should we take?
Well, in those circumstances, we would submit it would be appropriate for this court to reach its own conclusions on applicable law. You've had all the relevant matters placed before you. You've had all the relevant submissions as to its application made before you. This is obviously a case in which justice is served by the identification of the applicable law being made as soon as possible, and would respectfully ask the court to substitute its own conclusions. And I don't obviously repeat the submissions I made as to where that would take you.
And the outcome of applicable law applies to both open and closed.
Yes, my Lord. I mean, it raises a fascinating point as to if there are issues about which we don't know that engage in other law in closed, what would happen then? But that's not a matter that's before the court today. But I think the parties have proceeded on the basis that the applicable law will govern the determination of the dispute between appellant and respondent. My Lord, you're very grateful that you've given me a few extra minutes just to complete those submissions. Unless there's anything further I can assist the court with, those are the submissions on behalf of the respondent.
Great from Mr. Hammer. Thank you very much. Sir James.
I wanted to start, if I may, with 2 points on the approach in principle. The first relates to the approach to sections 11 and 12. There was yesterday, as you will have heard from Mr. Hammer, at least an initial attempt to defend an approach in principle that effectively involved narrowing either the idea of a tort or to try to link the idea of a tort with issues for the purpose of achieving the same end. So there was some initial suggestion that, for example, and in particular, liability was more important than damage. It was closer in principle to the heart than, for example, causation or damage in relation to a tort. The position which we have ultimately reached after the exchanges between my learned friend and the court yesterday is that any such attempt to try and narrow the concept of a tort in the way that was initially suggested has effectively been abandoned. My learned friend has accepted, correctly as we submit, that there is for this purpose no distinction between liability in terms of their intrinsic importance, between liability or causation or damage. He has accepted that all of the elements of the tort need to be considered in the analysis under sections 11 and 12, and therefore that the word tort used throughout those sections means all of the events or elements, to use the language from the statutory scheme, of the torts that are asserted. He has accepted that one element of those torts is no more intrinsically significant for that purpose than another. And he has finally accepted that the court must focus on all of the elements of the tort for the purpose of assessing significance under section 12, and that concept of significance of factors does not open up some wider, as I put it in opening, moral or normative set of factors. So he has in essence accepted our analysis of the way in which those concepts operate under sections 11 and 12, and our analysis of what the Supreme Court actually decided in VTB. Again, despite an initial suggestion that they, that is the Supreme Court in VTB, had treated the tort as being, as he put it yesterday, the wrong that has been done, in exchanges he had to retreat from that position, accepting, as he correctly had to, that the Supreme Court in VTB had referred to and relied upon each of the relevant elements of the tort that went to make up the tort in that case, which was the tort of deceit. So they relied upon the fact that the representation there had been made in England, the fact that they had been relied upon in England, and the fact that the loss occurred in England. So that is the position that we have now helpfully perhaps reached, because the issues of principles for the approach under section 11 and 12 are virtually agreed. I wanted to make a couple of points, if I may, despite that, about reasonable expectation, which my learned friend has made some submissions about. Again, there has been a significant retreat orally in relation to his position in relation to that. As you are aware, Dicey and Morris, as both sides acknowledged, have treated reasonable expectation as being one of the underpinnings of conflicts of laws generally.
Yes.
But he did not press the argument ultimately as a significant part of his analysis. His touch ultimately had to be and was a lighter one, despite the significance of this strand of the Court of Appeal's analysis. The ultimate suggestion appeared to be that reasonable expectations, when introduced into the analysis under sections 11 and 12, reduced the weight of the general rule, as he put it, and were, as he also put it, significant to the balance, that adjective, under section 12. And we respectfully submit that there are two problems with that approach. Firstly, that approach to the significance of reasonable expectation and the analysis that section 11 and 12 require, introducing it in that way into that analysis is simply not what the provisions do or say. They create a general rule and preconditions to the general rule or the general rules applying, and if a general rule is established, and when it is established, for example, because there was injury in the foreign country, then it simply follows that the weighted balance in section 12 applies. That's straightforward at the section 11 stage, and it's straightforward at the stage at which the comparative approach applies and the various factors that are referred to in sections 12, 1 and 2. There is, we submit, no need and no room for the introduction of a new test into that set of statutory provisions, which, as my learned friend repeatedly asserted, were designed to provide simple and clear rules. That leads to the second objection to the introduction, or the purported introduction, of reasonable expectation as a key strand in the analysis under sections 11 and 12, which is there are, as we submit, strong objections to the introduction of such a test into that statutory regime. Certainty and clarity, we submit, are a key underpinning, and were, it's evident from the Law Commission's report, a key underpinning of those statutory provisions. And if you were to introduce reasonable expectations as a general idea, you create a series of extremely difficult, if not imponderable and unanswerable questions into that regime. How does it play in? What does it mean? You introduce, at the very minimum, a considerable degree of complexity which is simply absent, and the possibility of endless argument, which is simply absent if you just straightforwardly apply the language. So in the end, my learned friend, after some of those difficulties were the subject of exchanges with the court, effectively said, well, simply put it aside. I don't need it. And he said pretty much the same thing in relation to his previous attempts to narrow the concept of tort for the purpose of sections 11 and 12. All of that we entirely accept is a proper and realistic position for him to take in his oral submissions. The difficulty, of course, that it creates for him is that if you are not prepared to defend ultimately the logic and principled sense of those positions, it becomes a great deal more difficult to defend a judgment in which those features played an important, and at least in one case, a pretty central part. Against that backdrop, therefore, I turn to what might be thought to be a key point in the case, which was the subject of some short submissions at the end by my learned friend directly relating to the Court of Appeal judgment, but was a subject and a theme which ran all the way through the oral submissions that he made. In essence, he says that the Court of Appeal did not apply an incorrect focus on the, quote, conduct. Now, whether they did or they didn't is, of course, a question of the court's view, having fairly read and sought to understand the judgment and reasoning of the Court of Appeal. And I'm sure little that I can say will assist you with that exercise. Our submission, however, is that they did apply an incorrect focus in that way, and that they had no basis for concluding that the judge had erred in taking a broader approach to the question of the focus that sections 11 and 12 require. Just a couple of points, if I may, in relation to that, perhaps 3 or 4 short points in relation to that. First of all, the judgment at paragraphs 1 to 6 of the Court of Appeal, which has been referred to in argument, recite in some detail the key elements of the actions of the United States in the assumed facts that we are dealing with. But the Court of Appeal's analysis, so they are referred to as a fair summary of what the pleadings actually say about the actions of the United States. The difficulty and the concern with the Court of Appeal's analysis is that when they got to do the analysis in that part of their judgment, they unduly and too narrowly focused, no doubt accepting the submissions which my learned friend made before them and has effectively repeated before you, that they unduly focus it simply on the conduct of the defendants. That was the core error they identified. And the concern is not that they were oblivious of the actions of the United States that had been the subject of the allegations in the points of claim, but that they applied the incorrect approach under the statutory scheme to the concept of the tort and what constituted the tort, and they narrowed matters unduly accordingly. And we placed reliance in that respect on the way in which the Court of Appeal both framed the issue, so I'm on the point about what happens when you fairly read the judgment, did they in fact do that? We rely upon both their framing of the issue and then how they applied it when they came to analyse the judge below's approach. As to the framing of the issue, we've been to these paragraphs before already, so I'll just remind you of them. In paragraph 25, page 140, they defined the tort as, quote, the conduct of the defendant which is alleged to be wrongful. That's the phrase, if you remember, Mr. Hermer produced when he was arguing about the principles at the beginning. The conduct of the defendant which is alleged to be wrongful, brackets, i.e. the tort, treating them as synonymous. They clearly equate the conduct of the defendants, the single element, with the tort overall. At paragraph 33, they recalled Mr. Hermer's submission, being that the judge erred by failing to focus on the tort committed by the services, which was, they said, the supply of questions with knowledge of his likely mistreatment. That, as they say, i.e. the tort, constituted the supply of questions to the CIA. And then when they come to apply that framing, having framed the issue in that way, they come to apply and resolve that issue in their analysis. Again, the key paragraph is 37. And they characterise in that paragraph, on any fair reading of it, the judge's key error as being the failure to focus on the defendant's conduct. No other element of the tort was identified there by the court, and you read 37 with 25, This is saying that the error was the failure to focus on the tort as defined there, and further in the second sentence of 37, that the tort is the supply of questions with knowledge of his likely mistreatment, and then they deal with the rest of the paragraph as you see in the third, fourth and fifth sentences. So we submit that that is, on any fair reading, an incorrect approach to the statutory scheme, which, as we've seen, requires focus on all of the elements of the tort. If the correct approach had been applied to the tort and all of its elements, that brings in as squarely relevant and important all of the US actions for all of the reasons I gave in opening. And it isn't simply a question of injury and location of injury. The damage and the injury flowed, as my learned friend I think has accepted in the last half hour, it flowed from the actions of the US. That's the case. From the detention, from the mistreatment, from the rendition, all by the United States. The causation of damage, realistically and centrally, as a result of that, US action. All outside the UK, none points to England. The passing of the question certainly was from England, but that contemplated action by the US abroad. And when one looks at the basis of liability, it's evident that in relation to all of these torts in their slightly different ways and without being sucked into the debate about accessory and joint liability again, in all of these, it is accurate to characterise the primary actor as in the actor that causes the damage in this way as the United States.
Well, can I go back to that then? Because under section 12.1, you have to start off by, first of all, looking at the significance of the factors which connect a tort with a country whose laws would be applicable under the general rule. You then describe the United States as being the primary actor. And so the significance of the fact that the injuries were sustained in the 6 countries, or some of the 6 countries, I don't know which ones, would be diminished by virtue of the fact that the primary actor in that was an agent of a foreign state, a different state, that is the United States of America. That was the point that I was trying to get across yesterday.
Well, I'm sorry if I misunderstood questions from yesterday, but the US law is one of the laws pleaded.
Yeah.
I think my lord said today it had nothing to do with the actions of the US, but the US is one of the 6 countries.
But you describe the primary actor as being the agents, the CIA.
Yeah.
And then you have to look at the significance of the factors which connect the tort to one of the 6 countries,
yes,
or the 6 countries. And diminishing the significance is the factor that the actions weren't in fact perpetrated by
Lithuania or whatever.
Yeah, it was all, the primary actions were by the United States of America.
My lord, that of course is true. My point is that the actions in question and the causation and all the rest of it are US actions abroad. They are actions in those countries, of course. They're not actions of the Lithuanian authorities, but you cannot escape from the fact that all of those US actions occurring there, in part, are not actions of the United Kingdom.
But that doesn't point.
They're actions which connect to Lithuania and Poland and all the rest of it, because those elements of the tort occurred there.
The injuries were sustained there, but the significance.
And the action which caused the injury.
Indeed, both of those, but all the actions were by agents of the Americans.
That is true, but the Americans were acting there, but nevertheless, those actions occurred in the foreign country. The causation of injury occurred in the foreign country. The injury itself occurred in the foreign country. True it is that they weren't Lithuanian actions or Polish actions, they were American actions, but they're all occurring there. So they are factors which link through America to those foreign countries, is my answer to my lord.
Thank you.
Were you suggesting that US law is one of the 6 laws?
It's one of the 6 laws that's been pleaded. They are, I think, Thailand, Poland, US, Morocco, Lithuania, Afghanistan.
That may be because of the Guantanamo action.
It's because of Guantanamo.
Yeah.
Yeah.
But I think that it's thought that the laws of Guantanamo might be a little bit different.
Well, there's a controversy over that. I haven't got time to go into it, but yes. But they are one of the 6.
Yes.
But that's how I put the connection, that's how I put the relevance of US activity linking to the foreign countries. It doesn't need to be the actions of the foreign country to create that link. And this is not the same error as VTB, to pick up the final sentence of the Court of Appeal's judgment in paragraph 37. This is not the same error as VTB that the judge is said to have committed. It's precisely not that, because once you focus on all of the elements of the tort, as VTB did, you're not looking just at some blurry factual background, you're looking to see what are the elements of the tort and who was responsible for them. That's exactly what the judge does. And still, for the third point on whether the Court of Appeal did apply the incorrect focus on the conduct, the Court of Appeal did not say at any point of their analysis, look at all of these elements of the torts. They include US action, they include US causing damage, they include the damage being suffered in the foreign countries. Now we examine which is more significant. They don't weigh the US action and the consequences of it at all. They don't do so because their focus is on the United Kingdom conduct to the exclusion, or at best to the minimisation, of the rest. See again paragraph 37. The tort committed by the defendant means the conduct. If it's all of the elements, the United States is plainly in, as we all agree. And their real answer to it is to say in paragraph 37, this is not a claim against the US. Well, it isn't, but that's irrelevant. What the Act requires is that you look at all of the elements of the tort, and that is the US. So this is not the US, a claim against the US is a separate problem, which I dealt with in opening, and there's no answer to this.
The focus must be on all the elements of the tort alleged against the defendants.
True.
Not the wider activities of the CIA.
Not the wider activities of the CIA, as it were, across the board, but in relation to all of the torts alleged against the defendant, actions of the US and their consequences are integral parts. That's my claim. That's my case. And if we are right so far about this problem with the Court of Appeal's reasoning, then the judge did not commit the error which has been ascribed to him as a matter of approach. I think my learned friend says that all the Court of Appeal was doing was to take issue with the judge's description of the conduct as being no more than one component in the overall exercise undertaken by the CIA. That's paragraph 37. He seems to rely upon for that. But that isn't, again, a fair reading of the judgment for all of the reasons I've given. See, in particular, the second half of paragraph 37 of the Court of Appeal's judgment and why the judge was said to be wrong in principle. They do not conclude that there was only one conclusion rationally open to him. They couldn't possibly be ascribed to that couldn't possibly be ascribed to the Court of Appeal. The error they identify and assert is one of approach. The judge looked at the wrong thing, they say. He should have been looking at the conduct of the defendant, not the US involvement in the ingredients of the tort. And the consequence of all of this, we respectfully submit, is that the judge was not wrong. Weight and evaluation, if that's right, were matters for him, see VTB. The Court of Appeal only gets to do its own analysis if there was an error of principle. And you can say there's an error of principle if there's a wrong approach, or if the judge reached a conclusion which was plainly wrong or irrational. But that wasn't the basis on which the Court of Appeal put it. They put it on the basis that he adopted a wrong approach. And we respectfully submit that that isn't that wasn't a correct conclusion for them to have reached. And we do respectfully submit that if you go back to the judge's judgment, he does approach the factors in the correct way. He directly and clearly titles his judgment so that they're all sequenced as Section 12 requires. He takes into account all of the various factors, connecting the tort with the 6 countries at 49 to 60, He carries out the same exercise for England and Wales, 61 to 63. He then carries out the comparative exercise, 64 to 70. And we respectfully submit that he makes no error in doing that. He's just weighing the significance of the factors that connect, focusing on all of the elements of the tort and recognising that the US is involved in all of them, and necessarily on the pleaded case involved in all of them. So far as the pleadings are concerned, I just wanted to make these points, if I may. Firstly, all of the allegations of fact that are made against United Kingdom agencies can be made and would sound in foreign law. Foreign law can be pleaded and has been pleaded precisely for that purpose. There's no difficulty in doing so. There's no need to search for the analogue or the direct equivalence, but there is no suggestion, relevant or irrelevant suggestion, that there was no ability to plead foreign law adequately in this case. So an English court will rule on the underlying allegations, whatever the answer, under applicable law. The weight of the allegations, therefore, and this seemed to be the purport of the submissions my learned friend made, these are super serious allegations, and of course they are, the weight of the allegations does not support English law, because those allegations will be ruled on by an English court, whatever the applicable law. The pleadings, in fact, indicate that none of the English torts against these defendants get off the ground without US action. Joint liability, accessory liability, actions of the US actually causing the injury, and all of that. And the key point I've made already in yours here too. It's a matter of evaluative judgment focusing on all of the elements. There has been some focus on the idea that there is significance to be attached to the fact that English defendants would be susceptible, or may be susceptible, to the application of the principles of public law and or to English criminal jurisdiction. I just make 2 points about that. Firstly, the extent to which that is so is a matter, and has for some years now been a matter, of extreme controversy at both levels. There may be controversy about whether the Human Rights Act applies. There may be controversy about what the nature of the public law unlawfulness, if asserted, would be. There may even be questions about the jurisdiction and the reach of the IPT, the Investigatory Powers Tribunal. There may be a whole series of complex questions about public law, and despite being no criminal law expert myself, there are also self-evidently very serious controversies as to the nature, extent and reach of English criminal law. So we've said that we will produce a note for Lord Stevens, but I'm not making any promises that we will be advancing positive assertions about the applicability of public law or criminal law. It may well be much, much shorter than that, and it may well be thought that it would be highly inappropriate in a sphere like this with these sorts of allegations for the government itself to be making any positive case about the nature and reach and scope of those two controversial areas of law. But we'll have a further think about that if we may. The second point I wanted to make was that the 1995 Act sets out its own tests and approach. And the question for the court in relation to these civil law claims for damages is, what does that approach lead to in this case? No more, no less. The fact that English authorities might be subject as public authorities to either or both of the other spheres of jurisdiction, criminal or public law, is, we submit, neither here nor there. I wanted, if I may, if I started a little bit late, now I focus just on one other area which I know the court was interested in, which is this question about misfeasance and whether you can split it out and how misfeasance might work and all of that. And I wanted to make these points, if I may. Firstly, as we discussed in opening, the application and the working out of what the applicable law may be may result in pros and cons for the parties. There is no requirement when you're doing the balance, there is no requirement to have regard to the fact that a foreign law might not be as favourable to a claimant or might not even provide a cause of action for the claimant. That is not the purpose of it, and that's the short answer in principle to all of this, even if there is no direct analogue in foreign law. So what is the answer in principle? In any event, and this is the second point, and it's a point I've made already, so I'll make it shortly again here, but it exists in this context too, the underlying conduct will be relevant to the foreign law torts in any event, because they provide the factual basis, and the pleaded foreign law against us provides the framework within which those facts would fall to be analysed. So if the point is essentially, which it appeared to be, a point about moral force, and the moral force that is inherent in the tort of misfeasance in public office, the moral force of holding a public authority to account will happen anyway, and therefore does not bear and does not weigh in the balances that Section 12 requires to be struck. And you will have seen from the pleading, see if you go back to the pleading, that in relation to all of the systems of law where the foreign law pleading has been done, there isn't a direct analogue, but pretty much all of them assert that there can be individual liability, or there can be claims made against individual officers. This bears on misfeasance and how it works in English law. There can be claims against individual officers, no doubt for which the organisations will be vicariously liable, under all of those systems of foreign law. Again, a feature which serves to undermine the point that if what is said is you must have something equivalent with the moral weight of misfeasance, you're going to get that anyway. Lord Sales, I know, was interested in the question as to whether or not you can split out things tort by tort. My submission in relation to that is, again, a short one. In principle, it is hard to read the sections, and in particular the bit of Section 12 that says or issues. I'm sure I've got the wording wrong, but you know what I mean, that bit in Section 12. It's hard to read that without that being a tort by tort or carrying the potential for a tort by tort analysis. So I'm not sure we're going to take a strong principled objection to that. What we would take a strong principled objection to is the idea that you could say, well, one of the torts must be English law, assume for this purpose misfeasance, the rest might be foreign law, and you can then use the misfeasance conclusion, as I think Lord Sales used the idea of a dragging anchor, to drag the other torts with it. And there is real force, we respectfully submit, in his follow-up question, which is, well, why does it work that way and not the other way? For the other torts dragging misfeasance in the other direction, if you can effectively make the same allegations a fact, and if there is no preclusion under the foreign law as there isn't here. So that is that. One final marker on this, if I may. Section 14, can you use Section 14 to drag, or can you use Section 14 to create the same effect? In other words, can you say the foreign law will be problematic in public law purposes because it doesn't contain the direct analogue? My first submission answer to that is there's no need to do that for all the reasons I've given earlier. Simply no need to rely on Section 14 for that purpose. It doesn't, there's no necessity to go there. But there would, we agree with my learned friend Mr. Hermer, be real difficulties and a real concern about whether public policy under Section 14 could be used for that purpose. It is designed, we submit, and its words make clear that it is designed to operate on the basis of a premise that the foreign law would otherwise be applicable. And that, I think, is the point that was made by the final sentence of the quote from Cox and Ergo that my learned friend referred you to at page 633 of the bundle in the judgment of Mr. Justice Turner. We respectfully submit that however much reasoning preceded that sentence in Lord Sumption's judgment, his instinct at the very least was correct, and that flowed most naturally from the wording of Section 14. And so that is that. One final point in relation to the concession in Belhage My learned friend has fairly and accurately taken you to the relevant paragraphs of the Court of Appeal and Mr. Justice Simon. There was a concession, but it was a limited concession in relation to China and Malaysia only. They were only some of the countries in relation to which foreign law was being asserted there. There were no concessions made in relation to the other countries, and the reason that the concession was made in relation to China and Malaysia was because they were detained under potentially normal immigration powers. But the significance of Belharsh, we respectfully submit, remains despite that limited concession, because both courts ruled, the Court of Appeal concluded it wasn't even close, as it were. And what my learned friend did not address was our concerns about why it was that Belharsh wasn't a fortiori, given the greater involvement of the United Kingdom authorities. So we do respectfully invite the court to place some weight, at least, on the force, the comparative force of Belharsh and indeed Rahmatullah, Belharsh particularly. And the comparative force is significant because a large part of my learned friend's submissions were to the effect that it would be absurd or unworkable because you'd have all these difficulties with lots of different systems of foreign law. But the practical point is that all of those difficulties would have arisen just as much in Belharsh and in Rahmatullah. And the answer was reached by those courts. There is also, and very finally, nothing in the idea that there are practical difficulties that flow from the fact that there may be material and information which is not known to the claimants and which might affect applicable laws and analysis and how that all works. The only thing that does is to illustrate that Parliament has decided that you can, in certain circumstances, to enable defendants in precisely this sort of case to defend themselves properly, you can have a closed hearing. And if you can have a closed hearing, you do not have to defend yourself by creating damage to national security. And if that creates limitations on information, then so be it. That's the balance that Parliament has placed into the hands of courts, because they have to make a Section 6 JSA declaration. There is no deficit in terms of the fairness or good sense of being able to litigate matters of this kind, and matters of this kind potentially by reference to foreign law rather than English law. I'm sorry, that's a bit of a canter given the time, but those are my submissions in reply.
Thank you, Sir James. Thank you, Mr. Hermer. We're very grateful to you and to all counsel in the case. We're also very grateful to those sitting behind you for their part in the preparation of the appeal. The court will take time to consider its judgment. The court is now adjourned. Thank you very much indeed.